The Stationary Bandit, a show about legal history and state formation. And as always, today's interview does not reflect the views of the employers of either my guests or myself.
Well, today I'm talking to Richard Epstein, professor at NYU, professor at Chicago, and my old Roman law professor. So, welcome, Professor. Thanks for being here today.
Yeah, I'm also, by the way, a fellow at the Civitas Institute, but I'll just mention it
All right.
because they will reproduce this podcast.
Okay. Well, so the first question I've got is a sources question about Roman law. So I've heard you say before that Roman law is better than the common law because, or one of the reasons it's better than the common law is because it was thought up basically by law professors working with hypotheticals who had a really good sense for things rather than judges who are presented with hard cases that create bad law. But I just wanted to ask, is that really an accurate representation of how the law developed, or is that just somewhat of an illusion we get by the fact that we basically have the jurists? Those are the main sources we have, so we kind of got law texts.
No, I think what it is an amiable exaggeration.
Okay.
It's not false, but what happens is the way in which the two systems worked is the Roman law system started from the top, and they were very good at categorization, much as if they were evolutionary biologists. And so they divide everything into this, into that. So first there's torts, and then there's contract. Then in the field of torts, you get the particular torts, the most important of which was the tort under the Lex Aquilia, the statute about various kinds of harms given by killing or otherwise destroying various kinds of things, animals and even slaves and so forth. And then you work down on both sides, you systematize the contracts and so on. So in the common law, what happens is there are some areas, mainly in public international law, where treatise writers seem to be enormously important. Battelle and Wharton and a bunch of other guys you've never heard of. But what they do is you get these very learned judges, and they take cases one at a time as they come to them. And so there are always the particulars of a particular case that confound the general issue. But remember, virtually every one of the classic common lawyers in the Middle Ages and behalf was very well trained in Roman law. And so what they did is they didn't write on a blank slate. The best illustration of this is a case called Coggs against Bernard, written by a very great English judge called, what was his name? Lord Holt. And what he did is he's had to figure out whether or not somebody who was shipping wine bottles for somebody else was going to be liable when they broke and spillage and so forth. And what he did is he was a bailee for shipment and so forth. And so he essentially went back, took the Roman categories, all 6 of them, with respect to bailment, figured out what the logic was with respect to the treatment of each and every one of these, and then figured out how to put this thing into the general system. He actually had a serious problem intellectually, because the Roman law system of bailments was simply a situation dealing with gratuitous arrangements. The basic rule was that you could never force anybody to make a gift. And so therefore the same rule applied in Rome as in England. But on the other hand, if you had a gratuitous arrangement, such as a situation where you held my goods for no fee, for example, that was surely a contract. And then the question was, what kinds of liabilities happen for the various ways in which those goods could be destroyed when they're in the possession of the bailee. And the Romans had much more complicated system than an ordinary rule of negligence or reasonable care. And they divided them into 6 classes, of which, the first of them was a gratuitous bailment, then there was a security for a loan, then there was a loan for use, and so forth. And what you then did is took each of these categories and figured out what kind of standard of care that you wish to have with them. The modern law tries to reduce this to something known as reasonable care, but generally speaking, reasonable care is a very poor substitute for the much more precise distinctions that the Romans made when they were talking about something. So my colleague Richard Posner made a very long and successful career out of explaining why the hand formula, which you know as well as I do, was the be-all and the end of tort law. Then you start looking back at the Roman category and you say, no way. It does not capture the way in which people thought of it. So what was the difference? Instead of using that calculus, what people did was they said, look, if you go to a commercial place and you store your goods. You are not making this with reference to the particular individual who happens to hold them. These are anonymous individuals. They're all professionals holding out a fancy sign, we do this for business. And so the standard of care with respect to them is objective. And if they don't meet it, too bad. But on the other hand, if it turned out that you put some suitcases or luggage of yours with a friend when you went away on vacation, you knew who that friend was. And if that person could not reach the standard of the ordinary professional merchant, you took that risk. And so they call this culpa labis in concreto and culpa labis in abstracto. I never remember which one is which. Actually, I do. Concrete means the particular guy. Abstract means the general rule. And then if you put that against the general social test of expectation, that fits exactly the way most people think about this particular problem. And so what happens is then you get this stuff talking about, oh, we just have a uniform standard of reasonable care. Well, what happened? You go to a jury and you have to try that. And you say, this guy basically picked this fellow and he has to take the risk that this fellow is going to treat his goods the way he always treats his own goods. And if that's below care, too bad. That's the understanding. And so what always happens is the way you teach lawyers to work is you go back and you master the old categories. And then when they say reasonable care, you basically say the reasonable care on a retail basis is defined by those kinds of relationships. And that is the way in which you actually win trial. And so if you recall in Roman law, we kept on saying, it's always the ghost kept coming back again one way or another, because they managed to hit a set of distinctions which actually really resonated with the way in which people do business. That then gets you into a larger philosophical situation. What do we mean by reasonable expectations, right? And this is not an unimportant term. If you look at the way in which, for example, modern takings law works, it's an expectations test, right? Investment-backed expectations. Penn Central, one of the all-time great disasters in the intellectual history of the Supreme Court. It turns out there are two definitions of what counts as an expectation. One of them is a simple prediction of what it is that you're likely to do. And since you're a very dubious character, it may well be that you'll steal or rob me or take what you have or whatever. And that's an expectation and it's a prediction. But one would hardly want to say, oh, you walked on a public street and you knew that there are people out there and therefore you expected to be mugged. And hence when you're mugged, you're taking the risk of that particular situation. That's not what we mean by reasonable expectation. That's an implicitly normative context. And what you mean by that is what kind of behavior do you and the other fellow have to have in order to make sure that any relationships that should arise between the two of you will be relatively productive. And that's much closer to the idea of a Nash equilibrium. I do the right thing consistent with you doing the right thing, which means that you have to have a set of customs that explain how it is that two random people sitting next to each other in a restaurant conduct their affair. So what do? We have two norms and they're both correct. Well, one of them is you don't talk too loud. Because if you start talking too loud, A, you disturb your neighbor. That is essentially a kind of a nuisance situation. And B, all of a sudden this information you have is going to blab out to everybody else in the world, and you don't want that. But on the other hand, if you're talking at the normal level, and somebody starts to lean over in their chair to get a better sense of what you're talking about, we know that that's a bad set of expectations, right? And even though it's predictable that it would happen, and nobody could say that the prediction is of conduct which turns out to be justified. And so what happens is we get this low-level situation. And then in restaurants, the question is how important are the norms, right? Well, if you're going to a restaurant in Chicago, the tables are further apart. Of course, the real estate is cheaper than it is in New York, where they're cheap by jowl. And so in the New York situation, the norm is actually more important because the interactions are more situation. But then somebody said, this is really important stuff. I don't want it to leak out at all. So what do you do in a New York situation? What you do is you have more private rooms because it turns out the social norm won't hold, not because anybody's doing the wrong thing, but because the physical circumstances don't allow it. So then you go to higher degrees of separation. And so what you do is you figure out the way all these things work. What you do is you become a natural lawyer in the old sense of that term, which is not only what people ordinarily do and expect to do. What the Roman lawyers did, and what I still try to do today, is you just watch the way in which people interact and talk with one another. And then from that, you try to figure out what those social set of expectations turn out to be. Now, the philosopher, whom I'm very fond of, even though he's a devout Catholic theologian, is a man named C.S. Lewis, who wrote a large number of things about how these things work. And his was always the sensibilities of the moral man. And so the kind of dialogues that he would quote, very instructive. He's kind of like a modern Plato. Somebody would come up to you and said, you know, you didn't come to lunch today. And the answer would be, sure, I didn't come to lunch today, but there's no legal obligation to come to lunch, so screw it. And then you ask yourself, would anybody say that? And the answer is there'll be somebody who will say it and will be promptly ostracized. Because what happens is there are a background set of norms which say when you make a promise which is not legally enforceable, and Romans laws had the same situation, there was nonetheless an expectation that you would essentially keep to it. And for somebody simply to deny the moral force of the process by saying, I don't care, would be crazy. So what happens is you then go through the usual kinds of things that you go through in a legal setting to sort of understand what it is. And so that's the kind of responses that you get. Oh, I didn't make it. I'm really sorry. I overslept my alarm. What you're doing is you're now telling them something of importance, which is this was not a deliberate snub, but was in fact an accidental breach. I have many students who oversleep their alarms and don't come to class. But what happens is after they say that, they don't say, gee, doesn't matter. But they say, well, when we go out to lunch next time, I'll pick up the tab, right? And so what you do is you have an implicit norm of compensation that is generally done. Maybe it will be accepted, maybe not. A lot of it depends on the relative social position, wealth of the two parties to the case. But what you do is you know that. And then there'll be other cases. I'm going to say, well, I mean, I really do have an excuse for this, is I got a very bad cold and I had to go off to an emergency room to take care of myself. And I couldn't get to the service because they cut it off in the building. Well, all of a sudden, you're not saying, in effect, that this conduct is justifiable. What you're saying is external circumstances frustrated the promise. And it's not even clear under those circumstances whether you have to pay. It's not like the alarm where it's your fault. This is a case where it's a neutral event. But you still reschedule, and then you work out something like that. And then finally, there's the case, yes, I was heading off to your place, and I got a call from the school, and they said my child had just injured himself in a playground accident. So off I was. And you know what? I forgot to call him. I am so sorry. But if I had called you, I would have told you I can't come. I wouldn't have told you that I've been there. And the other fellow says, I get it. Thank you for telling me about all these situations. So this is exactly the kind of dialogue that goes through when you have formal legal obligations that are in fact enforceable. And the point about this is it shows that we all live under an implicit moral order that is widely accepted. One of the things I like to do when I do this, I look at my class of left-wing students and right-wing activists and so forth. I say, how many of you disagree with this analysis? And what you find is, if you put it in the way that I just did, nobody thinks that there's a political coloration to either side of the argument. And you remember that when we talked about some of these issues in Roman. So what does that tell you? It tells you that talking about a natural law system is going to be utterly useless if you do it at a high level of abstraction. So that you say, well, they're divine and immanent and inherent rights of one kind or another. That's the way philosophers tend to talk, and it's largely useless. But if you, in fact, start going through the concretization, what it is the following situation. Prima facie case, remember that's a Roman conception, is you didn't keep your promise to come to lunch. And then there are various kinds of defenses that you can give with different sorts of consequences by way of excuse and justification. And that structure gets very strong abstraction, even though if you start to do some of the other things, it doesn't work. Now, Lewis was very interesting as a kind of commentator because he put this stuff together. And what he did is he proved that there was the evidence of the existence of God, because who else could give us that kind of moral code? The question then is, what do us standard utilitarians do? And this is the debate that goes back to Roman law and to earlier English law and so forth, in which the question is, are these rights given to us by some higher source, or do they simply develop spontaneously inside society? And the second position has the following view. If you look at these norms, it turns out that the social value of keeping these kinds of engagements is so enormous that if you had a norm that went the opposite way, society would start to fall apart. So what particularly happens is that people now say, look, even in a case where this particular promise may not be one I wish to keep, I'm going to do it anyhow because I don't want to take the risk of bringing down the whole structure, which will result in losses for thousands upon thousands of people, myself included. So that what happens is the reason these norms prevail is their utility is so great that it is very dangerous for a person who, in a particular transaction, rues the day he made the promise, he'll still keep it anyhow. And how do we enforce this? Well, it turns out people are always watching. And there's a book by Jonathan Haidt, one of his early works, in which he talks about the moral intuitions that are so strong that we have them before we even know that we possess them. And so what the Romans lawyers did is they just watched things. They were naturalists in the sense of seeing the way things behave. And they could well distinguish between aberrant forms of conduct on the one hand, and those conducts which seemed to be socially productive on the other. And so the answer was those norms that survive over a long time have a couple of characteristics to them. One is you're never quite sure on which side of the relationships you're on. So you don't know whether you're the guy who's breaking the luncheon promise or the one who's keeping it. And you realize that the one situation is so important relative to the others that you'll take a short-term loss to get a long-term gain, and you will get the approval of the crowd, that is everybody else in the world, watching you when you start to do this. Now, is this going to work in every case about promises and so forth? Well, the answer is no, because when you go back to the legal system, you have exactly the same argument, which says when you make promises with somebody else, what it does is it expands your capabilities and it extends their capabilities. So both of you are better off if you have the arrangement. And so generally they're self-enforcing. But if not, what you do is you have a legal system which will say, promise this way, you now have to do it legally enforceable. And why do we do that? Well, it turns out moral promises basically get you part of the way. But if the temptations are too big, people will start to cheat on the deal. And so if you're buying a house, you don't want to hand over $1 million to somebody else and wait 3 days to see if he's going to give you a deed. What you do is you now want means of assurance that the promises will be kept that will expand the capabilities that you have at the beginning to enter into advantageous creations. And that's exactly what we do. And so what are the doctrines? One is if they're supposed to be simultaneous obligations, you do not have to perform unless the other person has tendered performance as well. That is, it has to be a simultaneous exchange in which each of you benefit from the side of the other, because otherwise it will fall apart. And then in some cases where you wish to have a forward transaction, and in order to do that, you have to develop some system of security. And the Roman law, as you remember, for the most part, did a little bit through real estate mortgages, but for the most part, it was done by a very elaborate set of guarantees of one kind or another, so that if the primary obligor did not discharge the obligation, there were other people of distinction, note, and wealth who were standing up to back it up. And in that way, what you do is you could expand the trade gains from trade. And so you see, in effect, what's going on in these small cases, the moral cases. The stakes aren't high enough to put the apparatus in place, but as the stakes get larger, the dangers of self-interest become apparent, and you take steps against them. But nobody would say, gee, lots of people cheat on an escrow agreement and so forth. So therefore, I'm going to predict that he can do it. So therefore, it's okay that it be done. Nobody thinks that way.
Right.
And so what you do is once you do this, then all of a sudden people start looking at the world in very different ways. Because the next question you ask is, let's go to Nepal or to Zimbabwe and have the same situation. Now, it will differ. One place you're eating Japanese food, the other place you're eating Asian continental. But somehow or other, when you're talking about whether or not you show up for a meal, what's on the menu isn't the decisive feature. You assume you're going to get the food that you want. And these arrangements tend to travel very well across the world. And it does by imitation. Often happen. It also does exactly the same thing, takes place by independent creation. And so you start looking at legal systems. Not only do they have the very same parallel when you're talking about these developments, but there are certain tricks in the language that are very hard, that sometimes both systems will make the same legal mistake because they don't quite understand the way in which the elaborate system of presumptions ought to work.
Right.
And
I want to ask about mistakes.
yeah.
So Roman law, the classic one that even the writers in Justinian's code, acknowledge slavery not part of the natural law. You know, that's
Yeah.
one departure they even acknowledge. Are there any other places other than slavery where you think the Romans were systematically getting it wrong? You know,
No, the
some
Romans, by the way, their response was somewhat different from what you said. And the basic response was that this system was against the will of God. That was said in the or nature, said at the beginning of Justinian, but we have it as a social fixture. And now we have to explain how it works. And on this point, they were very reticent and very unhappy. So there's one sentence in Gaius which says, and by natural law, we basically have the right to enslave the people whom we conquer. And so, where does that come from, right? Well, it comes from the fact that it was a uniform practice. And one of the things to understand about slavery is, at least in the ancient world, it was not necessarily tied to racial differences of one kind or another. It was tied to conquest between rival people. And putting somebody as a slave was thought to be an act of mercy because you didn't slaughter that person on the spot. So it was a mutual improvement. Then the complications come. What do you do with the children? And, the Romans have a lot of difficulty with that kind of issue. In some cases, there's an urge for manumission, for getting rid of the arrangement. And then you get the cases where you have a free person as the father and a slave as the mother. Which are you? So you're slave. And they try to go through all these kinds of things as a technical matter. But the interesting thing about Roman law and slavery is virtually everything we know about this from the legal doctrine is not about people laboring in the fields and working themselves to death in the sun. It's about commercial transactions undertaken by slave for the advantage of the owner. And what happens is, when you teach early slavery, it's the beginning of the limited liability corporation in modern time. Because what happened under those situations is you're prepared to trust a slave to go this far but no further. And so what you did is you created a system where you gave the slave a trading stake called a peculium, and they could work with that, but it was generally understood, unless there was a specific guarantee from the master, that the only assets you could get were those that the slave had designated to have in their own possession. And that's like a limited liability corporation, right? And the point is, if you give notice of it, the other guy could then calibrate his action to reduce the size of the transaction to take into account the limited resources on the other side that back it up. And that's why Roman guarantors were so important in the case, because it allowed you to expand the gain from trade. They also had co-creditors, if you remember. I gave you an assignment on ad stipulation. And why did you do that? Because they had an imperfect theory of agency, and the co-creditor was somebody who, in effect, was allowed to sue on behalf of the primary debtor who was off at war somewhere else. But could they keep the money themselves? No. And so if you start looking at the Roman situation, what it does is it tells you how much more complicated the world gets. And this is still true today when you have three parties to a transaction instead of two parties to a transaction. So just to give one illustration about that, if you are acting on your own behalf and you settle a claim for less with somebody who's your debtor, you know exactly why you're doing it. The effort to pursue this whole amount of claim is not going to get you that much money because they don't have that much money. It will cost you administrative expense. So it's better to have a bird in the hand and two in the bush, and you settle it out. But on the other hand, now it's the agent who settles it out. He could be doing exactly the same thing if he's a faithful agent for the principal. But on the other hand, it's also possible there's a little bit of collusion going on. And what they do is they release the claim fraudulently and take some payment on the side and thereby prejudice the master. And then the question is, what sort of remedies you have to go against that? Well, one situation they had was an old remedy, which was very inflexible, that permitted you essentially to try to set aside the transaction. But sometimes it was more nuanced, and so what they then did is they developed good faith and bad faith rules to figure out when, under the so-called actio mandati, the act against an agent, you could recover from either the debtor or the principal, right? And so what happens is you now see that the Roman law has exactly the same kind of duality that you have in modern law today, which is there's one set of remedies which is very rigid, very fixed, and very clear, but somehow it doesn't cover every situation. And then what you do is you have another set of remedies, which is much less clear, a little bit moneyed, but if you know how it works, it turns out that it actually gets you better kinds of results. And so good faith remedies, as opposed to strict theorist remedies, are something that every commercial lawyer worries about this day. And why is that? Well, because there are only so many possibilities out there in the world, and it's exactly the same thing as before. If you're in Mozambique, you may have these promises with respect to a shipment of the local goods and produce. If it turns out you're in modern day, the issue has to do with the payment for a set of computer chips and so forth. But it doesn't matter. Alfred Hitchcock was a great movie writer, right? And there was always something you were looking for. You never quite knew what it was. The Maltese Falcon was the kind of case that had that. And 39 Steps. And what he said is the drama is not in the schmageg, that's what he called it, what it is you're going after. It's in all the intrigue that people engage in when they're talking about things of value and how they get it. And that's, for example, the dominant theme in 39 Steps and in Notorious, and so forth. Now, why do these movies translate so well into foreign languages? Is a very fair question, right? The answer is because the sensibilities are the same as you go across culture. And what you have to do is to give them a little bit of an explanation. And a guy in a toga won't know what cyberspace is. But if you brought him up to date, he'd understand the problem perfectly by knowing what the physical situation is. And so strangely enough, when you talk about something as a race, the thing subject to a transaction, it really doesn't matter what the race is in many cases for the general rule. And then it always matters when you're talking about customary practices that now the nature of the race really does matter. So if you have perishable goods, you have to deliver them very quickly. If you have durable goods, you could take a good deal longer in order to do so. And so therefore, time is of the essence. You've heard that phrase before, right? In one sort of contract, but it isn't of the essence on the other. Well, the Romans had this huge trade too, right? And they got silk, which lasted a long time, and then they get fruits, and those things had to be shipped very quickly. And indeed, one of the things that became very clear, both in America later on, is that when you have the railroad, rapid means of transportation, it turns out that you could take perishables and have a much larger market for them. Whereas in ancient days, they all had to be, by necessity, local. And so that created a risk of monopoly power, which you do not have to the extent that you have market transaction. So what you do is you always take these older rules and then figure out, well, how do we deal with these sorts of problems? And there's a famous issue, for example, in operations research. You got a large number of goods that you have to ship by boat. Some are perishable, some are not. The harbors are here, there, and the other place. And what you have to do is to figure out what are the orders in which you make the deliveries in order to maximize your net profit. And Hayek had this famous view that it was the intuition of the tramp steamer captain which determined that. And it turns out he was wrong. That was what you had back in 1944. But today, when you have these modern computer algorithms, what you do is you follow the algorithm. And so what Hayek confused is two very different notions, one of which is intuition, and the other is privatization. And it turns out that when you privatize and when you decentralize these various sorts of elements, the net effect of making that decision is it allows you to have the algorithm much more effectively than it's done by a government. And it's on and on. You look at any farmer today now, they have their computer program, and it will tell them when to plant, how much to plant, when to harvest, when to put it to the market, and so forth, because they can get the variables in. It's not 100%. There's a little bit of room for intuition at the edges. I feel the market's a little bit shaky and so forth and that. But for the most part, what happens is this mechanization takes over, and it's generally a thing for the good, because the lack of discretion turns out to increase the certainty on both sides of a deal, which is what we want. And the Romans did the same thing through standardization. They had very strong rules for fungible goods because it meant that you could substitute one for another, just the way I don't care which share of stock you give me, so long as the share of General Motors preferred. We have exactly the same thing, and they were the ones who started all of that, if you recall, with their partnership interests and so forth.
Yeah, so I want to understand some of why it persisted so long. I mean, Roman law, why it persisted so long. And the biggest confusion I have is that the kind of high classical period of Roman law seems to coincide with a period of a lot of very powerful and sometimes quite crazy emperors. And I kind of wonder why didn't Why didn't they ever wreck it? Like, what was limiting them? What's
Okay,
your
well,
understanding
it
there?
turns out the history is not quite right.
Okay.
Um, great debate in Rome is the switch from the Republic to the Empire, which was with Octavian becoming Augustus. And what they've done is studies to figure out what the level of commerce was in the two periods, before and after the takeover. And the way they measured this was to figure out how many boats sunk. And then you try to date the sinking of the boats. Now, why is that a situation? Because the perils of the sea, which today are kind of an abstract conception to most of us, were very real when you had these small boats, heavily laden, going through choppy water, and you didn't even have a tarpaulin over your head, and only the most primitive kinds of sail. And what they found is that the higher level of commercial activity took place in the Republic relative to the Empire. So what happens is you go back and you read the guys that you're talking about, Gaius and so forth, right? What you discover is that huge amounts of what they write are stuff that was written 100 or 200 years before by people who were lawyers during the period of the Republic. And so the Sabinians and the Proculaeans, two big guys, each having their own schools like Freud and Jung and so forth, they were active in the Republic. And what you can essentially say is that the centralization of trade in the government is conducive to special forms of abuse. You don't let the boats sail. You demand heavy taxes on these kinds of things. You want favors from them to ship your goods free of charge and so forth. And in the end, all of these costs imperceptibly reduce the volume of trade that take place. And so the Romans had a kind of a complicated version of freedom of contract that they applied. It's important to know what it was, but that generally only worked best when it was free from government interference, and that government interference became a much more serious problem when it turned out that you had emperors who had various people who could impose taxes that could slap the life out of everybody else. So I don't think that was the correct way of doing it. The other way was to figure out, well, how do you have freedom of contract in a world in which you don't have very effective writing, or you have only limited resources? And what the Romans did was they said, we're concentrating the freedom on terms like price and delivery, which you can never set in the abstract. You can't write a banksman contract that said all these goods have to be delivered on October 1st, 301 AD. Not going to happen, nor the price. But all the incidents, the warranties and so forth that went with the goods tended to be standardized, which meant the warranty of fitness for the purpose, warranty of merchantability, the warranty of title. These things were generally imposed as a matter of law. And the reason they did that is 95% of the people wanted these warranties in any event. They all survive today in modern law for exactly the same reason. But if in fact you have to put them in there, the transactional uncertainty is going to be greater than you would want. So you make them terms that everybody has to live with. And when you do that, the standardization now allows you to go forward with transactions with merchants with whom you might not have otherwise personal arrangements. So it's exactly the same thing that we talked about earlier on with a commercial bail-in. Standardized terms essentially allow these transactions to take place. And this is not in ancient times an antitrust violation, right? In modern time, you always have to ask about standardization. Are you trying to form cartels and so forth? To which the general answer is 99% of the time the answer is no. And in the other cases, you have an antitrust law, which is going to focus on market power. Antitrust considerations, as best I can tell, only appear indirectly and obscurely in the Roman sources because you did not have the aggregations of capital that would allow that to take place. And you recall when we talked about Roman law and the Roman law of partnerships, one of the things that we stressed was that all Roman partnerships had only general partners. They didn't have limited partners. And once you say that, it turns out it necessarily limits the size of the partnership because you can only have active traders. You can't have passive investors. Those people only join in if there's a way that they could cap their liability. And that's what the modern limited partnership and what the modern corporation does. It gives them limited exposure in exchange for a surrender authority over the particular transaction, which is put into the hands of an elite group that everybody knows and generally trusts. And so the limited partnership is much more common for large operations than the general partnership, just as the corporation is much more common with limited liability than some kind of a corporation in which everybody comes together and the liability is not limited to their share contribution. So, I mean, that kind of all fits together in one sort. And it's the point of doing this way is you hope if you understand how the Romans worked with the set of limitations that they faced, right? You'll understand how commercial transactions are put together, and you'll have a better understanding of the modern system than if you only study traditional common law rules. Because
Right.
there's more than one way to basically slice up a cake.
Right. I want to understand a bit more about the origins of Roman law, and I'm curious. Do you agree with the view that you still hear the claim plenty of people make today, but I don't know how well grounded it is, that the origin, at least of rules around violence, is in feud law, basically, as it is in many legal systems around the world. Does that seem right to you, that it originally starts as a system of rules about kinship feuds?
Absolutely. I mean, look, the general situation is there two kinds of wrongs or three kinds of wrongs that you can experience. One is somebody can knock your brains out by beating you up with a stick. Another is they don't have to perform a promise. And the third one is they cartelize against you. Now, what you have to do is to ask yourself, which of these risks is the greatest? Well, it turns out cartels are hard to form. You don't see it much of a problem. And in fact, if you're worried about breach of contract, the best remedy is always pick reliable trading partners, at which point the enforcement issues will be rules. But you don't get to pick the guy who wants to kill you. And so the first set of rules are always to exclude that guy. And if you go back to the classical philosophers like Hobbes and so forth, they're absolutely obsessed about the question of whether it is that one person who engages in violence can upset an entire society of people who wish to trade in peace amongst themselves. And so controlling that particular outsider became the dominant feature. So most systems begin with libertarianism, and not so much on the fraud part of it, independently in financial cases, but with the force part of it. And then, of course, if you're going to use force, what you always try to do is to deceive the other person into laying down his guard. And so you have fraudulent situations, right? You come up to somebody, and what you do is you extend a hand in friendship, and the moment he extends his hand, the other hand comes back with a dagger and sticks him in the back. And so force and fraud become teammates. The force is used after the fraud softens somebody up to make him an easier target. And that's absolutely the situation today. So that's where you begin. And it turns out that's a complicated notion because if you remember, there's a statute in Rome in law called the lex Achillia, and its first title has to do with ocytera, which is the killing of a slave or a herd animal of one kind or another. And so what does ocytera mean? Does it just mean to kill? No. It turns out it comes from chitera, chitera. It means to kill by cutting. And so what they were really worried about was sticks and stones and swords and so forth, which are the direct forms of attack. At this point, the question then comes, well, you could kill in many ways, including theft, or not stealth. And so the case that the Romans start to give is what you do is you take a bowl of food, put some poison in it, and set it before somebody, and they eat it in ignorance of what's going on. And somebody says, well, did you kill him? No, he killed himself when he ate the porridge, right? Well, there's nobody in the world that has ever accepted that argument, given that the trap was delivered. And so how do you then deal with it procedurally? Well, you could pretend that it's a cutting when it's not. But what everybody does is they develop what they call a set of anti-circumvention rules, which are rules which are designed to deal with conduct which has very little social value, if any, but is intended to get you out from underneath the explicit prohibition in the statute. And the Romans therefore developed the notion of causa mortis prestare, furnishing a cause of death, and take it literally. You furnished him a plate of food which he ate in ignorance. Well, suppose now he knew that it was poison. At that particular point, it's a different case. Because can you prove fraud if the other guy knows the truth of the underlying circumstances? And the answer to that question has always been no. Then you ask yourself, well, if you tell him that you've got poison there and you wish to kill him, he's not going to eat it. And so the case in which there's general knowledge is not the case in which it's going to happen. It's the case in which the deception takes place. Or you say, oh, this food is perfectly poisonous, and either you swallow it and die peacefully, or I'm going to cut you to ribbons. And at that point, well, the answer is I took it under coercion. And so mistaken coercion become the circumstances which allow setting food before you to do this. And then you generalize. You dig a hole in the ground, cover it up with straw. Somebody comes along with his oxen and his carts, and they fall into the hole because they're deceived by the appearance. Well, you say, I didn't kill you. You fell into the hole yourself. And what we say, no, no, no. You created a deliberate situation with deception and so forth, and you're responsible. Then what happens is, well, the next case comes along, and somebody creates the hole, and they really don't want to kill anybody. So what they do in their haste is they put a set of boards on top of it, which are not sufficient to hold the weight of a standard wagon that goes along those roads. So the guy then drives the thing across the road, falls into the hole, and now you have the question, is it only a deliberate harm that gets you responsible? Or does it turn out to be a harm which is not deliberate? It turns out to be a harm which in fact is done either through inadvertent or done by an honest mistake. And so you then have the learned debate about culpa, blameworthiness. Is it the case in which if you really thought about it and believed that you had put boards over there of sufficient weight and did not notice that one of them had a latent defect in it because it was latent as hidden, are you excused? Or does you take the risk of making the wrong calculation? And that debate turns out to be the negligence and strict liability debate, which you see very clearly as early as Gaius. And it's the identical debate that takes place in a case called Brown and Kendall in 1850. Same confusion, same mistakes, same kinds of reasoning. And so what happens is the reason why natural law tends to work is that to the extent that early on it is very heavily predicated on physical arrangements of one kind or another, or natural biological processes, these things tend to vary very little, right? Between different places. And so the laws tend to spread horizontally across cultures and vertically over time.
So I want to ask you a bit about the biological variation, because I know that you're a fan of kind of sociobiology, evolutionary psychology literature. And I'm curious, have you read any of Joe Henrich's recent work? Are you familiar with him?
No, I've never heard of the man.
Okay.
I mean, the way I do sociobiology is scandalous. Back in the 70s, I actually read the literature out of mere coincidence. I was at a dinner party with my friend Lisa Landis, and she said, oh, there's this man, Edward Wilson, who writes about interesting things about biology. And at that time, it wasn't psychology, it was sociobiology. And I said, oh, and then I started to read it, and I said, hey, this is all very familiar. And so their parent-child conflicts, famous paper by Trivers in 1974. Oh, that's just the same kind of problem you have with agency costs when you hire a lawyer or an agent to represent you. And we've already talked about that in connection with the ad stipulator, the co-creditor, right? And so you go through it, and it kind of makes sense. And then there was a seminar at the Center for Advanced Studies in Behavioral Sciences on sociobiology. And I was fortunate enough to be invited there when I was 34, 1977, 1978. And this man, David Barish, had just written a book on sociobiology, and he organized the seminar. And across the room, there was a man named Daniel Kahneman of great fame, who was at the peak of his powers at the time, doing all this stuff about cognitive bias. And I was the only person in the whole place who actually went to both sets of seminars. Kahneman was deeply suspicious of evolutionary theory. And the evolutionary guys had so much to worry about what they thought big stuff that they spent very little time on cognitive mistakes. They spent most of their time on efficient strategies to make sure that you take care of your children. And so for them, the central notion was one called inclusive fitness. Most people have not heard of it. It's a paper everybody should read by a man named W.D. Hamilton. He wrote it when he was in his early or mid-20s. The genetical foundations of human altruism. And what he says is, you're just not a person taking care of yourself. civilization would last a grand total of 0 generations if you didn't take care of your kid. Well, do you go out dancing when your child has the stress? And the answer to that question is not really, right? In fact, you come home from the party if your kid has the stress. Well, what's that? That's your genes talking to you. So if you don't take care of that set of problems for that child, what it turns out is your gene line is going to disappear. And so what you do is you have become not altruistic in the sense of taking care of a stranger, but the ratio is pretty clear. If you could put in 1 unit of energy in order to help your child get 2 or more units of benefit from it, since they have 50% of your gene, you decount the 2 by 1/2. And so now it's 1:1. So over the 2-to-1 ratio, you do it. Under the 2-to-1 ratio, you do not. Well, when children are small, right, that ratio is not 2-to-1. It's probably 100-to-1 and so forth. And then it slowly gets smaller. And then it points at some point, weaning or whatever the time is, it starts to change very radically. And you then have to figure out when the child is going to be autonomous and separate from the parent. And the theory of weaning is difficult for the following reason. The child, when it is nursing, gets 100% of the benefits from the parent. The parent only gets 50% through the child. So if the ratio is now 1.7-to-1, the parent wants to stop and the kid is quite happy to go on, right? And you have these sort of conflicts that take place. And what's nice about the sociobiology is that it ties into the standard accounts of Jensen and Meckling on agency costs that are used elsewhere. And so it shows you again how these things move from one area to another.
Right.
Well,
So one of the thing that I wanted to ask you about here, so Joe Henrich, the guy I brought up, he is in the generation, and I'm the wrong person to fully explain this, but I can give a kind of thumbnail of it. So he's broadly in the world of the cultural evolution people. So basically, he talks about genes. We've been genetically selected for social learning and
for cooperation,
living, and exactly, and for living specifically in groups where we can learn from each other. So specifically, we have evolution toward cooperation with a specific group that we are going to be able to learn from well.
Well, that's what I began with, right?
Exactly. But one of the things that he looks at in terms of legal institutions is, well, legal political institutions broadly, is the way that different social vehicles, I guess, change over time and make different underpinnings for different institutions. So the thing that I was kind of curious about asking you about is he has this recent theory that is somewhat controversial, but a lot of people are excited about it, about basically the idea that the Roman Catholic Church eliminated kinship groups in Europe over, basically 400 to 1400 by eliminating cousin marriage in Europe, and basically shrunk down all of the kinship networks that had existed in, German and Roman society.
I think that's a bit trickier.
A bit tricky? Okay.
Well, let's say why, because essentially what happens is if you inbreed too much, there are real biological deficits. And the issue is whether or not the Roman hierarchy, to some extent, stifled individual at the bottom layer. And I actually wrote a long paper on this, exact topic, knowing nothing about this man, about those religions that are top down and those which are bottom up. And the bottom up is the group called the Congregationalists. And they have very, very different situations in terms of their leadership and so forth. And what happens is if you are a congregation, right, the term gives it away. That's all you can be is a congregation. You can't be 10 congregations and working together under control. So what do? What they tend to do is they have various associations of which they become members, which give them information on how to deal with common problems that they have to face. And if they're going to work together, it's only going to be on a selective joint venture for this purpose only thing rather than a union. So you get both kinds of situations. And what you see is that both of them tend to survive. But when you look at its growth situations, remember what I said about limited partnerships, they are necessary for growth. And so it is that an organizational hierarchy is necessary for growth as well. So knowing nothing about this man, I think you have to be careful about it, but there is no question that certain kinds of organizations stifle dissent. Now, you look at the Mormon churches, if anything, is even more social centralized than that, right? And not only are they centralized, but it turns out they have a very hierarchical situation between men and women, just the way that the Roman Catholic Church does with respect to situation. What's amazing about the Mormon church is an extraordinarily high level of participation by women, even more than it is, it turns out, by men who tend to be a bit more rebellious and often break out. And that's something you have to understand. And so, what does the Mormon church do? I mean, these people are extremely skillful. Is they develop non-religious, non-official functions that are run by women largely, social arrangements of one kind or another, so as to keep them directly engaged in the operation. And then they have a model very different from the Catholic Church, which is they do not allow any congregation to get bigger than, say, 100 or 200 families. You know why? Their attitude is not the Jewish tradition of buying yourself out by giving something to the congregation on Rosh Hashanah or Yom Kippur for the drive. Everybody has to have a personal contribution of one kind or another, take out the coal, print up the mimi over the magazine and so forth, sweep up the church or whatever, because they don't believe that you can survive as an effective entity if you can monetize the relationship. And other organizations seem to believe that you are. So I think all of these variations are very much on the table. But I think I'd be a little bit curious to say that, the Catholic Church drove out all sorts of inferior organizations of one kind or another. My guess is if you study the details of the institutions of each of them, what you would discover is that the parish priest had a fair bit of discretion in the way in which these things were organized. And that a lot of the ceremonies that kept people together were done in local hands. I mean, somebody said about the Catholic Church is they know when to get you. They go for birth, they go for marriage, and they're after, and death. And those are the three pillars around which all things are organized. And they have a lot to say about each and every one of them and how they work.
So,
So it's
to be fair, I think the position is not that it eliminated all rival organizations, but instead that it specifically eliminated these, family-based organizations. His thesis is largely that kind of before early modern Europe, or before kind of the high Middle Ages, most of Europe was, most political organization, people were tied mostly to their kinship group, and that the Catholic Church, by over time making those difficult to maintain by limiting cousin marriage, you got smaller and smaller families, which meant that people engaged in more voluntary organizations and larger political institutions.
Yeah, but again, I mean, inbreeding is very bad. And so, let me give you an illustration, and then I'm going to have to go in a minute or
All
so.
right, right.
But you look at kibbutzes, right?
Mm-hmm.
Now, what is the common feature of kibbutz? Essentially, it has to be small because, like the Mormon congregations, everybody has to have an active role with everybody else, and everybody is mixing and having communal deals and so forth. What is the one feature about kibbutzim that essentially is striking? Virtually all marriages take place with somebody who's not a member of a given kibbutz. Why is that? Well, you've developed kind of brother-sister kinds of relationships with all these people for 20 years. Then to turn out to say, oh, let's go to bed, guys. It just doesn't work. And so they get hybrid vigor by going outside the kind of arrangement. And one of the things that he did not mention, or that you did not mention in this account, is what's the role of trade in these kinds of situations. And so if you take something like the Hanseatic League and so forth, what you discovered is that there were guild-like structures that took place under Catholic offices, and they had monopoly rents and so forth. But what they did, in effect, is they often traded with outsiders. And so the function of the guild was, in modern terms, had efficiency properties by allowing you to organize larger units to trade with other larger units outside, and then have monopoly element by keeping out locals, one kind or another, from joining your particular type situation. And so when I see large claims like that, then I ask the second question, wait, there was a Protestant Reformation. What kind of changes did that make? And then, I mean, there was a Roman church in Italy, a Roman church in Northern Italy. a Roman church in Milan? Are they all going to operate under the same rules? How much control does the Pope have with respect to the ways in which these individuals operate? And my guess is when you had a Pope living in Avignon for a couple of hundred years and so forth, those arrangements didn't have the kind of dominance that he's talking about. And so I, having done some study with respect to the Catholic Church, am a bit suspicious about the grand claim, but there is no question that there's a certain truth there, which is if you have large and powerful organizations, they will throttle small organizations. So let me just give you one example about how this can kind of work. I used to live in a place called Dunewood in Michigan, and it was a coastal community, and there was a risk of flooding that took place all the time. And so what happened is the local community organized a bunch of people who understood the system pretty well, and they figured out how to organize the drainage system so as to make sure that the water didn't flood and back up into all the homes. And they were very good at it, and nobody paid them anything, right? It was a mark of prestige and so forth. Then the Army Corps of Engineers comes along, and it has its own set of protocols. So what happens to this local community? Well, now these guys aren't local savers. They're felons because they're essentially challenging the authority of the United States. And so the whole thing had to be disbanded lest people get themselves into serious problems. And what happened to the level of care that you got? Well, local knowledge, a Hayekian theme of the way in which drainage systems work, may respond to large and general principles, but these guys actually had watched it for years and they knew what to do. Army Corps of Engineers came in, erratic. They didn't have any local stake, any good feedback mechanism, and so things got worse. And there's always that problem. Does the larger expertise offset the local knowledge? And as I mentioned to you with the tram steamer, sometimes the correct solution is to keep local control, but to have greater technical expertise in starting to run it. And so to that extent, I'm not so worried about any kind of boundedness. But anyhow, I hope you enjoyed the conversation.
Yeah.
I have to run off.
Thank you so much.